Hello everybody, I'm delighted to be with you today to continue my discussion of cryptocurrency regulation. Today's webinar is the second of 7 webinars I'll be doing over the next few weeks covering crypto regulation in Hong Kong and how and in what ways it compares to crypto regulation in other jurisdictions. Turning now to the webinar. Today I will be continuing the discussion of virtual asset regulation and the FATF recommendations by considering the progress made by jurisdictions in implementing the FATF recommendations. We'll then transition into a discussion of Hong Kong's regulatory regime, analysing the SFC's regulatory reach, the regulation of virtual asset portfolio managers and virtual asset distributors. So let's start by looking a little further at the progress that's been made in implementing the revised FATF recommendations. In order to assess the progress made by jurisdictions in implementing the revised FATF recommendations on virtual assets and virtual asset service providers, VASPs, the FATF conducted a survey in March 2020 of its membership and its broader global network. 38 FATF members, 37 jurisdictions and 1 regional organisation, and 16 FATF-style regional bodies, FSRBs, responded. The results of the survey indicate that, overall, jurisdictions have made progress in implementing the revised FATF recommendations. That's Recommendation 15 and its interpretive note to Recommendation 15, INR 15. Among the responding jurisdictions, 35 jurisdictions had implemented regimes for VASPs, while 19 jurisdictions didn't have regimes for VASPs as yet. For jurisdictions that established regimes for VASPs, 32 jurisdictions introduced regulatory regimes allowing VASPs, while 3 jurisdictions prohibited VASPs. Among jurisdictions that had not yet implemented regimes for AML-CTF, the majority, 13, intended to regulate VASPs, 2 intended to prohibit VASPs, and 4 had yet to decide. As I mentioned in Webinar 1, one of the challenges that the FATF report highlighted was the global implementation of the travel rule. VASPs are required to implement the FATF's AML-CTF preventative measures in recommendations 10 to 21 set out in INR 15. This includes Recommendation 16, which sets out wire transfer requirements and is a key measure to ensure that the originators and beneficiaries of financial transactions are identifiable and are not anonymous. VASPs and financial institutions have to comply with these requirements for virtual asset transfers. This is the so-called travel rule. Although the FATF is technology neutral and doesn't prescribe a particular technology software, the FATF guidance on virtual assets and VASP, published in June 2019, lists a range of technologies which may enable VASPs to comply with aspects of the travel rule requirements. However, the FATF report explained that there was no technological solution that enabled VASPs to comply with all aspects of the travel rule in a holistic, instantaneous and secure manner. Notwithstanding these concerns, the FATF report explained that jurisdictions have made progress in the development of certain technologies to provide a solution to the travel rule. There seems to have been progress in developing technological solutions for the travel rule, which include progress in the development of technological standards for use by different travel rule solutions. An international industry-wide initiative has been established to set global technical standards for travel rule solutions. A first messaging standard that sets a common universal language for the communication of the required originator and beneficiary information between VASPs was developed. This initiative may now be undertaking work on further messaging standards and the maintenance of this standard. Several different travel rule solutions are being developed in line with the decentralization ethos that underpins virtual assets. There appears to be a greater desire for multiple potential solutions as compared to one centralized travel rule solution. However, the FATF report explained that use of a common standard will assist in ensuring that different computer systems or software are able to exchange and make use of the information which is exchanged pursuant to the travel rule. And from a jurisdictional point of view, the FATF report highlighted that of the FATF recommendations, there has been lower implementation or adoption of the travel rule when compared to the other AML-CTF requirements. Of the 32 jurisdictions that have implemented the AML-CTF regulatory requirements for VASPs, 15 jurisdictions advised they introduced Recommendation 16 requirements for VASPs. This delayed enforcement of such requirements can be attributed to the lack of adequate holistic technology solutions, highlighting the importance of the need for the swift development of technological solutions. Notwithstanding the concerns in relation to the travel rule, the FATF report explained that these concerns are not obstacles which will prevent the development of technological solutions to implement the travel rule. So the FATF report has urged that VASPs increase their efforts towards a swift development of holistic technological solutions to cover the entirety of the travel rule. As I also mentioned in the previous webinar, a key aspect of the implementation of the travel rule is the ability of a VASP to identify the counterparty VASP. Compliance with the travel rule requires that VASPs must be able to identify when they are transacting with another VASP as opposed to transacting with a private wallet, and whether the counterparty VASP is registered, licensed by the jurisdiction and is adequately supervised for AML-CTF purposes. The FATF report notes that the best way to conduct this due diligence on the counterparty is to do so in a timely and secure manner. A possible solution to the obstacles faced by VASPs is to create a global VASP list. This approach would require that information be collected from each jurisdiction on the VASPs registered or licensed in that particular jurisdiction, which would then be accessed via a central database. However, this central database approach has its own challenges, which include but are not limited to ensuring the information on the database is secure, assigning responsibility for maintenance and accuracy of the data, determining who would supervise the bodies responsible for collecting the information, and deciding who would have access to the information. Peer-to-peer transactions through private or unhosted wallets. Peer-to-peer transfers of virtual assets without the use or involvement of a VASP or financial institution are not explicitly subject to AML-CTF obligations under the revised FATF recommendations. This has resulted in many VASPs being unsure of the required approach. In such circumstances, and they have raised queries as to what approach is required when transacting with private or unhosted wallets. Concerns have been raised to the extent to which a wallet can be identified as a non-custodial as opposed to a custodial wallet, causing some VASPs to ask for guidance on the extent to which blockchain analytic tools can be used in complying with the travel rule requirement. A further concern that's been raised is whether VASPs should be able to transact with private wallets, and if so, what kind of AML-CTF requirements need to be put in place to mitigate the risks. When considering the issue, some VASPs have raised the risk of unnecessarily burdensome AML-CTF compliance obligations, including the travel rule, which may incentivize greater use of peer-to-peer transactions through unhosted wallets and raise the risks and require further mitigation measures. Batch and post-facto submission and past transfers. Some VASPs have also requested guidance on certain other issues. The extent to which the batch data submission of transfers of originator and beneficiary data is permissible under the revised FATF recommendations. Whether originator and beneficiary data could be submitted on a post-facto basis, for example at the end of the day or 5 to 6 business days later, instead of immediate data submission on an individual asset transfer. And the extent to which beneficiary and originator data should be collected on past virtual asset transfers. For the smooth global implementation of the travel rule, different solutions need to be of such capability that different computer systems and software are able to exchange and make use of the information being shared. This also requires that the technology must have in place adequate controls to address data sharing, storage, and security. The first step to ensuring interoperability of systems is the development of global messaging standards. However, fragmentation may be driven by the different rules and standards adopted in different jurisdictions for areas such as privacy and data protection, cybersecurity, or AML-CTF. The interoperability of different travel rule solutions may then be impacted unless sufficient flexibility is being built into the messaging standards, or solutions are being developed to accommodate the requirements of particular jurisdictions. This highlights the importance of close cooperation with and within the private sector and amongst jurisdictions in developing their AML-CTF regimes and supervisory approaches. As less than half of FATF members have introduced travel rule requirements, there's a lack of a global framework for travel rule compliance. This poses a challenge to VASPs, since it's unclear what approach they should take in dealing with VASPs located in jurisdictions without the travel rule. Several specific wording issues with the FATF guidance regarding Rule 16 for VASPs were raised, including references to the legal entity identifier, the term account number, and the address of an originator. The FATF report also noted that the adoption and implementation of the AML-CTF obligations globally is at an early stage. This is partly due to the fact that many VASPs may be unfamiliar with the fundamentals of AML-CTF, as they may previously have had no regulatory oversight. This is said to be compounded by the speed at which the VASP sector develops and changes. Notwithstanding this, jurisdictions which already have a developed AML-CTF regime for VASPs and have imposed this on their VASPs have reported an improvement in overall compliance, with increasing awareness and attention to AML-CTF obligations. This is particularly apparent in larger, well-established VASPs. Turning now to Hong Kong's domestic crypto regulation and the progress that Hong Kong has made in relation to the FATF's recommendations. Hong Kong regulates entities conducting activities in cryptocurrencies where the relevant cryptocurrencies are securities or futures contracts, as defined in Hong Kong's Securities and Futures Ordinance. Intermediaries conducting regulated activities in relation to cryptocurrencies that are securities or futures contracts are required to be licensed or registered by Hong Kong's SFC and have to comply with the AML and CTF requirements of Hong Kong's Anti-Money Laundering and Counter-Terrorist Financing Ordinance, the AMLO. However, the vast majority of cryptocurrencies, such as Bitcoin, are not securities under Hong Kong law, nor are cryptocurrencies regulated by Hong Kong's other financial regulators. The Hong Kong Monetary Authority, the HKMA, has said that it does not regulate cryptocurrencies such as Bitcoin, which it regards as virtual commodities and not as legal tender or a means of payment or money. Hong Kong's banking laws and regulations therefore don't apply to entities accepting or dealing in cryptocurrencies. The Money Service Supervision Bureau of the Customs and Excise Department in Hong Kong has also said that Bitcoin and other similar virtual commodities are not money for the purposes of the Anti-Money Laundering Ordinance and are therefore outside the scope of its regulatory regime for money service operators. However, on the 3rd of November 2020, Hong Kong's Financial Services and Treasury Bureau, the FSTB, published a consultation on proposals to introduce a new licensing regime under the Anti-Money Laundering and Counter-Terrorist Financing Ordinance for virtual asset exchanges that are not required to be licensed under the SFO because they only trade cryptocurrencies that are not securities or legal tender. The proposals will require licensed virtual asset exchanges to comply with the AML and CTF obligations set out in Schedule 2 to the Ordinance, and the SFC will monitor and enforce compliance with these obligations. If implemented, the new regime will fulfill FATF's requirements for virtual asset exchanges. This will be discussed in more detail in my fourth webinar on the 29th of January. Hong Kong is not, however, considering regulating other entities within FATF's definition of VASPs at this stage, such as certain types of wallet providers. On the 1st of November 2018, the SFC published new regulatory standards which apply to virtual asset portfolio managers and distributors of virtual asset funds that are already required to be licensed. Separately, the SFC invited virtual asset trading platforms and exchanges which are interested in becoming licensed to join the SFC's regulatory sandbox with a view to potentially becoming licensed if the SFC determines that they are appropriate for licensing following the SFC's assessment of their performance in the sandbox. The initiative was an important step forward as it demonstrates the SFC's willingness to engage with participants in the crypto industry. There have been calls from the industry to introduce regulation in order to create legitimacy for players willing to comply with regulatory standards. With the HKMA and Money Service Bureau seeing cryptocurrencies as outside their realm of authority, the SFC finds itself caught in a somewhat perhaps ambivalent position. The SFO gives the SFC authority over the securities and futures industry, but this gives it only limited authority over entities conducting business in the very limited category of cryptocurrencies, which are securities or futures within the statutory definitions. In short, licensing requirements apply to firms carrying on regulated activities as defined in relation to virtual assets. These are an exchange providing trading services in virtual assets which are securities or futures, and of course many are not, firms managing funds that invest in virtual assets which are securities or futures, and firms distributing funds which invest in virtual assets, irrespective of whether they are securities or not. The SFC has therefore stretched its regulatory reach as far as possible by imposing stringent regulation on fund managers and distributors of funds investing 10% or more of their gross asset value in cryptocurrencies under regulatory standards laid out by the SFC in November 2019. This is a significant first step, and I'll explain the licensing requirements the SFC imposes shortly. However, despite many of the world's largest crypto exchanges operating in Hong Kong, these remain unlicensed since they're outside the scope of the SFC's licensing regime, as they only trade cryptocurrencies, which are not securities or futures contracts under the SFO. The SFC refers to these as non-SF virtual assets. So an exchange which only trades non-SF virtual assets, or a firm which only manages funds investing in non-SF virtual assets, is at the moment unregulated. There's also uncertainty as to whether ICO tokens are securities under the SFO, and this has led to calls for greater clarity on cryptocurrency regulation in Hong Kong. Managing money laundering and terrorist financing risks associated with virtual assets and VASPs. In response to the FATF's revised recommendations, which I was talking about previously, the HKMA published a notice on the 16th of December 2019, the HKMA FATF notice, and the purpose of this notice was to provide guidance to authorized financial institutions in relation to revised FATF recommendations. The HKMA FATF notice reminded authorized institutions that when they establish and maintain business relations with VASPs, appropriate risk assessments should be carried out to differentiate the risks of each VASP, recognizing that there is no one-size-fits-all approach. The approach adopted by authorized institutions will depend on the nature of the relationship between the authorised institution and the VASP. As such, authorised institutions have to undertake additional customer due diligence measures, which include the collection of sufficient information to adequately understand the nature of the VASP's business, determining from publicly available information whether or not the VASP is licensed or registered and subject to AML or CTF supervision, and assessing the AML-CTF controls of the VASP as appropriate. The HKMA FATF notice explains that the extent of the customer due diligence measures employed by the authorised institution should be commensurate with the assessed money laundering, terrorist financing risks of the VASP. Before introducing new banking or investment products, authorised institutions should also undertake money laundering, terrorist financing, risk assessments, take appropriate measures to manage and mitigate the identified risks in accordance with the applicable legal and regulatory requirements, which include the requirements set out in the Guideline on Anti-Money Laundering and Counter-Financing of Terrorism. As I mentioned before, the SFC's regulatory jurisdiction under the SFO does not extend to activities in the many cryptocurrencies, including the most widely traded such as Bitcoin and Ethereum, which are not securities or futures contracts. As I said also, these are referred to as non-SF virtual assets in Hong Kong. Primary market issues and offers of cryptocurrencies such as ICOs, which are not securities, are also unregulated. The SFC has issued a number of warnings to potential investors of the risks of investing in cryptocurrencies. No doubt with a view to the FATF requirements, the SFC published a regulatory framework in November 2018, which extended its regulation of the activities of licensed fund managers and brokers to cover their crypto-related services. In short, the SFC imposes regulation on virtual asset portfolio managers and virtual asset fund distributors, which are already required to be licensed, either because they also manage portfolios of traditional securities or futures contracts, which requires an asset management license, or they distribute funds investing solely in non-SF virtual assets. Fund distribution requires a securities dealer license, that's a Type 1 license, because a fund is a collective investment scheme, which is a security irrespective of whether the fund invests in virtual assets which are securities or not. The SFC has applied additional licensing conditions to both types of firms to the extent that they manage portfolios or portions of portfolios that invest in virtual assets or distribute funds investing in virtual assets. Portfolio management includes both fund management and management of discretionary accounts in the form of an investment mandate or a predefined model portfolio. Firms distributing virtual asset funds, whether as fund managers under an asset management license or as fund distributors under a securities dealer license, are required to comply with the SFC's regulatory framework for licensed corporations, including its Code of Conduct for persons licensed by or registered with the SFC, the Code of Conduct, including, amongst other things, Know Your Client and AML and CTF obligations, as well as an obligation to ensure the suitability of product recommendations and solicitations for particular clients, and additional requirements, including extensive due diligence in relation to the virtual asset funds they distribute, their fund managers and counterparties. So let's take a detailed look at the regulation of virtual asset portfolio managers. Firms managing virtual asset portfolios, whether as licensed asset managers or as licensed securities dealers, will be subject to additional licensing conditions. These will apply to two types of firms. Firstly, firms managing traditional securities and virtual assets. Additional licensing conditions will apply to firms which are or are to be licensed as asset managers because they manage portfolios of traditional securities or futures contracts, and also manage or plan to manage portfolios investing solely or partly in virtual assets. The additional licensing conditions are subject to a de minimis provision, such that they apply to an intermediary if it distributes virtual asset funds which have a stated investment objective to invest 10% or more of their gross asset value in virtual assets, or intend to invest or have invested more than 10% of their GAV in virtual assets, directly or indirectly. That means a fund of funds that invests in derivatives, such as total return swaps, which have virtual assets as the underlying. Secondly, firms distributing funds investing solely in non-SF virtual assets. The licensing conditions also apply to firms which distribute funds which only invest in non-SF virtual assets. These firms are not required to be licensed as asset managers, since the management of a fund which doesn't invest in securities or real estate is outside the definition of asset management. However, a firm that distributes this type of fund in Hong Kong must be licensed as a securities dealer. That means a regulated activity type 1 dealing in securities. The SFC will impose the licensing conditions for virtual asset fund manager on its securities dealer license. The licensing conditions do not, however, apply to licensed corporations which only manage funds investing in virtual asset funds, that means funds of funds, or licensed corporations managing portfolios whose mandate is to invest mainly in securities and/or futures contracts, and their investment in virtual assets exceeds 10% of NAV only because of an increase in the prices of the virtual assets held in one or more of the portfolios. The licensed corporation is required to take all reasonable steps to reduce the portfolio's investment in virtual assets below the 10% of the GAV threshold. If, however, the position is expected to continue, that means that virtual assets will continue to exceed 10% of GAV. The licensed corporation must tell the SFC, which will consider imposing licensing conditions. Failure to notify the SFC could result in disciplinary action. All existing licensed corporations and licensed applicants are required to notify the SFC if they currently manage or plan to manage one or more funds that invest in cryptocurrencies or intend to hold cryptocurrencies on behalf of funds under their management. The notification requirement applies even if the fund intends to invest less than 10% of the portfolio's gross assets in cryptocurrencies, and whether or not the cryptocurrencies involved are securities or futures contracts. Failure to inform the SFC may constitute a breach of the Securities and Futures Licensing and Registration Information Rules. On being informed that a firm is managing or plans to manage virtual asset portfolios, the SFC will send the standard licensing conditions to the firm, and these may be varied following discussions with the firm according to its particular business model. Licensed corporations which do not agree to comply with the licensing conditions will be prohibited from managing virtual asset portfolios and must unwind their cryptocurrency positions. A new license applicant will have to agree to the licensing conditions proposed, or its licensing application will be rejected. The SFC has published pro forma terms and conditions that it will impose on a fund manager that manages a virtual asset fund. The conditions are fairly onerous and include certain principal obligations, a restriction to professional investors, and disclosure requirements. Investors in a fund with a stated investment objective of investing in cryptocurrencies, or which intends to invest 10% or more of its GAV in cryptocurrencies, are restricted to professional investors as defined in the SFO, which includes high net worth investors under the Securities and Futures Professional Investor Rules. If a virtual asset fund will be distributed through distributors, the virtual asset fund manager has to implement measures to ensure that the fund is only distributed to professional investors. Despite the SFC acknowledging that crypto funds face a unique challenge to the limited availability of qualified custodian solutions, the SFC has imposed onerous obligations on licensed virtual asset fund managers in relation to custodians. A manager of a virtual asset fund is firstly required to assess and select the most appropriate custodial arrangement. That's whether to hold the assets itself or with a third-party custodian or an exchange. Taking into consideration the advantages and disadvantages of holding cryptocurrency at different host locations by way of hot or cold wallets, considering, among other things, the ease of accessibility to cryptocurrencies and the security of the custodial facility. Virtual asset fund managers are also required to exercise due skill, care and diligence in selecting, appointing and conducting ongoing monitoring of custodians by reference to factors such as the custodian's experience and track record in providing custodial services for cryptocurrencies, regulatory status, particularly whether its cryptocurrency custodial business is subject to regulatory oversight, corporate governance structure and the background of its senior management, financial resources and insurance cover for compensating customers for loss of customer assets, and operational capabilities and arrangements, for example, its wallet arrangements and cybersecurity risk management measures. Where cryptocurrencies are held by the licensed fund manager itself, it's additionally required to document the reasons for self-custody and disclose the risks of self-custody to investors. Appropriate measures must be implemented to protect the fund's assets and to effectively segregate the cryptocurrencies from the fund manager's own assets in the event of its insolvency. The fund manager is also required to use best endeavours to acquire and maintain insurance cover over the cryptocurrencies. The SFC recognises that there are currently no generally accepted valuation principles for virtual assets, particularly ICO tokens. The licensing conditions will, however, require licensed corporations to select valuation principles, methodologies, models and policies which are reasonably appropriate in the circumstances and in the best interests of investors. These will also need to be disclosed to investors. Virtual asset fund managers are required to set appropriate limits for each product or market the fund invests in. They should, for example, consider setting a cap on a fund's investment in illiquid cryptocurrencies and newly launched ICO tokens and its exposure to counterparties. According to the risk management procedures set out in Appendix A to the pro forma terms and conditions, virtual asset fund managers should consider using more than one custodian to hold the fund's assets to avoid undue concentration of risk. Periodic stress testing is also required to assess the effect of abnormal and significant changes in market conditions on the fund. Before transacting with a crypto exchange, a licensed virtual fund manager is required to assess the reliability and integrity of the virtual asset exchange, taking into account matters such as its experience and track record, legal or regulatory status, corporate governance structure and background of its senior management, operational capabilities, mechanisms, for example, surveillance systems implemented to guard against fraud and manipulation with respect to products traded on the exchange, cybersecurity risk management measures, and financial resources and insurance cover. Exposure to individual crypto exchanges must be limited by setting appropriate caps. The SFC has noted that the accounting profession has no agreed standards and practices for how an auditor can perform assurance procedures to obtain sufficient audit evidence for the existence and ownership of virtual assets and ascertain the reasonableness of the valuations. Despite this, the SFC will require the appointment of an independent auditor to audit the financial statements of managed funds. Although the difficulties have been acknowledged by the SFC will nevertheless require licensed corporations to consider auditors' experience and capability in checking the existence and ownership of virtual assets and ascertaining the reasonableness of their valuation in their selection of an auditor. Liquid capital. A licensed fund manager which holds cryptocurrencies on behalf of the funds it manages is required to maintain liquid capital equal to the higher of 3 million Hong Kong dollars or the amount of its variable required liquid capital. To date, only 3 fund management firms have met the SFC's onerous standards for licensing. Diginex Group's Digital Asset Group was the first to obtain SFC licenses for its management of funds investing in cryptocurrencies in June 2019. The first pure cryptocurrency fund to be SFC licensed was a fund tracking Bitcoin prices launched by VentureSmart Asia, whose rollout was announced in April 2020. Most recently, Huobi Asset Management, the asset management subsidiary of Huobi Technology Holdings, was licensed by the SFC on the 31st of July 2020 for regulated activities Type 4, advising on securities, and Type 9, asset management. Given its parent company's background in the crypto space, there has been speculation that Huobi Asset Management may lead the way in crypto exchange management. A fund manager which only manages funds investing in cryptocurrencies that are not securities doesn't need to be licensed for Type 9. This is because asset management is defined in the SFO as the management of securities or real estate. Managing a fund investing only in cryptocurrencies which are not securities is not therefore asset management and doesn't require a Type 9 license. However, the distribution of a fund will require the distributor, whether that is the fund manager or a third-party distributor, to be licensed for Type 1, dealing in securities. A fund is a collective investment scheme, which is within the SFO's definition of securities, irrespective of the type of assets the fund invests in. A Type 9 licensed asset manager, which also distributes the funds it manages, can rely on the incidental exemption from the Type 1 licensing requirement. The SFC's circular to intermediaries on the distribution of virtual asset funds on the 1st of November 2018 requires licensed corporations to comply with the SFC's Code of Conduct for persons licensed by or registered with the SFC in distributing virtual asset funds. In particular, they have to ensure the reasonable suitability of any recommendation or solicitation made to a client under paragraph 5.2 of the Code. The circular also sets out additional requirements which apply to distributors of virtual asset funds, which are not authorised by the SFC for retail distribution under Section 104 of the SFO and have a stated investment objective of investing in virtual assets or intend to invest or have invested more than 10% of their GAV in virtual assets. That's funds which the licensed corporation knows or should reasonably have known to be investing more than 10% of their GAV in virtual assets at the time it distributes the fund, unless it's been told that the fund manager intends to reduce the fund's investment in virtual assets to below 10% of the fund's GAV in the near future. The investment in virtual assets may be direct or indirect. That means through a fund of funds and funds which invest in derivatives, for example, total return swaps, with virtual assets as the underlying. The additional requirements that apply to licensed corporations distributing these funds include selling restrictions. A distributor of a virtual asset fund can only target professional investors as defined under the SFO, except in the case of institutional professional investors, which are broadly banks and regulated securities intermediaries. The distributor must also assess whether its clients have knowledge of investing in cryptocurrencies or related products before effecting a transaction on their behalf. A transaction can only be executed for a client without such knowledge if this would be in the best interest of the client. However, the SFC has given no guidance on when a transaction can be considered as being in the client's best interests. For the purposes of the knowledge assessment, a licensed corporation can take into account a client's prior investment experience in private equity or venture capital, or whether they have provided capital for a startup business in the previous 2 years. A particularly difficult obligation on licensed corporations is a requirement that they have to consider the aggregate amount to be invested by a client in virtual asset funds to be reasonable, given the client's net worth. Thirdly, due diligence on virtual asset funds not authorised by the SFC. Licensed corporations will need to conduct extensive due diligence on virtual asset funds unless they've been authorised by the SFC for retail distribution. Their fund managers and parties providing trading and custodian services to the funds also have to have DD carried out on them. However, licensed corporations' compliance with these obligations very much depends on the willingness of the various parties to disclose the required information. The assessment licensed corporations will be required to make are difficult given the lack of developed standards in the industry at the current time. The due diligence is required to include an examination of the fund's constituent documents and completion of a due diligence questionnaire, in addition to making inquiries of the fund manager to obtain an in-depth understanding of certain issues. In relation to the fund manager, a licensed distributor is expected to make inquiries in relation to the fund manager's background and relevant experience, and the track record of its senior management, including its chief investment, operation, risk and technology officers. Due diligence is also expected to be carried out with regard to the fund manager's regulatory status, compliance history, and its internal controls and systems. Due diligence on systems and controls should cover, for example, the existence of proper segregation of key functions such as portfolio management, risk management, valuation and custody of assets, or of adequate compensating controls to prevent abuse. Who has authority to transfer assets from the fund, the persons responsible for, and the procedures for reconciling transactions and positions, including the frequency of reconciliations and the methodology and the persons responsible for determining the pricing and assessment of the reasonableness of the predetermined price of cryptocurrencies. The SFC also expects a licensed distributor to conduct due diligence in relation to the fund manager's IT infrastructure, for example, in terms of security and access management, its risk management procedures, including concentration limits, counterparty risk, management procedures, stop-loss arrangements, and stress testing, its liquidity risk management policy, and disaster recovery plan. In terms of the due diligence the SFC expects a licensed distributor to conduct in relation to the fund, this should cover the fund's targeted investors, list of instruments the fund intends to trade or invest in, and any limitations on the size of its holding of ICO tokens, pre-ICO tokens, or other illiquid or hard-to-value instruments. Its valuation policy, especially for ICO tokens, pre-ICO tokens, or other illiquid or hard-to-value instruments. Fourthly, the custody arrangement for the fund assets, including the policy on the allocation of assets to be kept at different host locations, such as exchanges, custodians, hot storage, cold storage. Fifthly, its use of leverage and derivatives. And sixthly, the fund's targeted risk and return per annum. 7, key risks, which I'll talk about in information for clients. And 8th, the fund's auditors and audited financial statements, including whether the fund has received a qualified audit opinion in the past and whether, the 9th point, the audited statements are up to date. The due diligence the SFC expects a listed distributor to perform on the fund's counterparties should cover their legal and regulatory status, for example, whether they're regulated by any authorities to undertake custody business or trade in cryptocurrencies, their experience and track record in dealing in cryptocurrencies, the robustness of their IT systems, including cybersecurity risk management measures and contingency plans, and their financial soundness and insurance coverage, for example, whether they have insurance covering loss of customer assets. Provision of information to clients. To help clients to make informed investment decisions, licensed distributors are required to provide prominent warning statements covering certain risks such as price, volatility, security, and so on. For licensed virtual asset fund managers, which both manage and distribute crypto funds, the requirements may not prove problematic, particularly where they provide custody for the cryptocurrencies themselves. The due diligence obligations are likely to be more problematic for Type 1 licensed fund distributors, depending on the willingness of third-party funds and their fund managers to provide the degree of information required. For licensed fund managers which manage funds investing in virtual assets and distribute those funds, the requirements should not be particularly problematic, particularly where they provide custody for the virtual assets. The requirements are likely to be much more problematic for Type 1 licensed fund distributors, where the extent of due diligence they will be required to perform on third-party funds, their fund managers and custody arrangements may not be practical. That brings me to the end of the formal part of this presentation. So I think that brings me more or less to the end of this webinar, and thank you very much again for joining. As I mentioned earlier, this is the second webinar of a 7-part webinar series. Part 3 will be on Friday the 22nd of January, and I'll continue with a discussion of crypto regulation in Hong Kong. You're most welcome to join me. You can find a link to register on our website, charltonslaw.com. And for those of you who've already registered, I look forward to seeing you next week. And to all of you, have a great weekend, and thank you very much.